Welcome. We're back. Now we're going to go through Chapter 13, Lucky 13, learning about title records. And of course, as you should know, we're going to be covering a lot more definitions, and hopefully I will explain it in a way that helps you understand it a little bit better. Okay, are you ready? Let's get started. We're going to talk about public records, and that's an easy way to know. Public records, what are they? Of course, they're records that are open to the public. Anyone who is interested in a particular property can review records to learn about documents, claims, other issues that affect the ownership. Typically, an attorney or title company will perform a search of public records to ensure that the title will be good when it's conveyed. And today with the internet, with our computers and our smartphones and everything, you can search about anything and find out about everything and anything about anybody if you want. And sometimes you have to pay a fee, but everything's open to the public, and those are public records. Public records will contain the detailed information about every parcel of real estate in a city or county. Recording, as you know, a lien to get paid has to be recorded, and based on the who gets paid first is who got recorded first. So recording is an act in placing the documents in the public record. That's why we record everything. But the one thing that doesn't have to be recorded to get paid, as we talked about, is real estate taxes. They always take priority. Real estate taxes take priority and play prior to anybody else getting paid. Deeds, mortgage loans, and other instruments that affect the title to a property must be recorded in Illinois in the county in which that property is located. No instrument affecting title to the property can include any provision prohibiting recording. Like if I'm going to do a contract for deed, I'm going to do owner financing for you as a buyer. I cannot prohibit you from recording it. Sometimes individuals who do owner financing do not want you to record it because they may still have a mortgage loan on it, and they're not supposed to be doing this. So an instrument affecting title to property, if it prohibits recording, that prohibition is void. A deed in any language other than English here in the United States, although it may be valid between the parties, does not give constructive notice unless an official English translation of the document is attached at the time of recording. The translation cannot be done by the family member, children, whatever. It must be prepared by a credible source such as a local consulate or of the country in which the language is used, or a licensed translator. Needs a profession. Now notice, there's more than one type of notice we're going to talk about. We talked about public notice. Well, now we're going to talk about constructive notice right now. Okay? Public notice is basically opening up to the public. But constructive notice is a legal presumption that information may be obtained by an individual through a diligent inquiry. So if you want to get notice on who owns the property across from you, if you search on the internet, you're doing constructive notice. It takes some effort for you to turn on your computer, search on the internet, etc. By going down to the recorder's office and recording the documents, that also serves as public record, public notice, constructive notice. And by going down, waiting in line, etc., now that takes physical activity, okay? And if you don't record the deed I gave you, but you simply move into the property, you have also served notice. That's constructive notice. Moving into a property takes physical effort again, correct? So a memory tip for you, based on constructive notice or actual notice, construction work takes physical effort on the person. By going and recording the documents, whether it's you or somebody else on your behalf, you have to go down there, stand in line, record, etc., takes physical effort. So does moving into a property. Physical effort, okay? Actual notice is basically not only the information is available, but Also, someone has been given information and they actually know it. So if you actually basically see me moving into the house, I'm giving constructive notice, but you, on the other part have actual notice. By me going and recording my deed, I'm giving constructive notice. But by you viewing the public records, you're getting actual notice. So remember the two different types of notices. Actual is visual. They sound, they rhyme similar. Actual is visual, seeing something. Priority. Priority is the order and right in time of which party who filed or receives notice first. First one who's recorded is the first one in line for payment. Except one party, real estate taxes. They will always come first. Certain types of liens are not recorded. Some examples are some taxes are not recorded until past due, but real estate taxes will become a lien against your property, and they don't have to be recorded and take priority. Chain of title. So when they search public records, a lot of times they search through the title records, going back and back and back to day one. Chain of title, think of it, chain, okay? If you look at the chain around your neck, it's made up of little zeros like little O's. It looks like a chain, right? So chain of title, for definition, is the record of the property ownership, going back, way back in time. But in Chicago and Cook County, they can only go back as far as when they had the big Chicago fire, when Mrs. O'Leary's cow kicked down the lantern, and because all the documents were basically destroyed back then. So they can only go back as early as 1875 or something like that. An unbroken chain of title can be traced through linking conveyances, like who owned it before you, before them, before them, before them, back to the earliest record owner. That's chain of title. If the ownership cannot be traced through an unbroken chain, then they call a gap in the chain. Well, like if your chain on your neck you're wearing, if it's broken, there's a gap. Okay, well, then there's a cloud on the title because of that gap. They're missing an owner. So the cloud on the title makes it necessary to establish ownership by a court action called suit to quiet title. Suit to quiet title. Memory tip, as I told you, chain of title is made up of an O. A chain is made up of all little O's, or they may look like oblong O's or rectangular O's, whatever, but they're linked together. Owners. It's the history of the ownership of your property. In Illinois, a mechanics lien that has not been recorded may still have priority over other liens that have been recorded if it increased the value of the property, but it will never, ever, ever take priority over your real estate taxes. So we talked about chain of title, the history of all the owners on the property. Now we're going to talk about a title search and abstract the title. In the examination of all public records, they search the title to determine whether there's any defects that exist in the chain. Memory tip for you to try to remember the difference between chain of title, the owners, and abstract the title. Abstract the title is a summary of all matters. Abstract and all begin with an A. So it's not only who owns it, it's what liens are on the property, et cetera, et cetera, et cetera, et cetera. Okay, it's all matters affecting the title to the property. Was there an encroachment that was basically a title company insured over, et cetera, et cetera. So abstract the title is everything, all matters. Chain of title is just the owners. In Illinois, when they search title for a property, when you're purchasing a property, the normal title search in Illinois goes back 40 years. So that's one thing basically you're paying the title company for. That's one thing an attorney is doing for you. But if there's a possible litigation exists between today and 40 years back, then the search they do will have to go back 75 years. So even if its litigation is not against you, maybe it was against an owner that owned the property 10 years ago or 20 years ago. They now have to go 75 years back when they search title. Because when you purchase property and when you are getting a title insurance policy, well, your contract is going to specify who's going to pay that policy. Customarily, the seller pays for the owner's policy. And when you're purchasing a property, you want to make sure you have marketable title, which means you want to make sure that it does not disclose any serious defects. You want to make sure that you're not exposed to any possible litigation or threatening your quiet enjoyment of the property. The quiet enjoyment, the right to use the property, has not been sold to anybody else, etc. Proof of ownership. Nothing's going to guarantee you anything in life 100%, okay? In life, nothing's going to guarantee you 100%. Even if you listen to my tapes day in, day out for a whole year, you're not going to be guaranteed 100% to pass that state exam. It's up to you to put everything we're giving you into work, and remember and be cautious on reading questions too. Most of the time people get things wrong because they don't read it. So nothing's going to guarantee anything in life 100%. Evidence that the title is marketable is called proof of ownership. The deed itself is not considered sufficient evidence. A certificate of title and title insurance are commonly used to prove the ownership. But could there be an error? Yes, but the title insurance company basically is insuring the property. Certificate of title is basically a statement of an opinion of the title status on the date the certificate is issued, usually prepared by your attorney. As I said, a certificate of title is not really a full guarantee of ownership. It's proof of ownership. An abstract of title, or an attorney's opinion, basically it's a summary of all recorded documents. Could there be something, though, against the property or something that was never recorded that pops up later on? Possibly. It's usually considered evidence of title. See, many times when people buy brand new construction, the developer of that new construction many times will tell you, you know, to brand new construction, you don't need an attorney. Well, I will tell you, that's when you really need an attorney. Why? Because nobody else has owned that house. It's been vacant. So we've got to go all the way back 40 years. An attorney is your best insurance when you're buying, selling property. And many times they even use it for large pieces of property when they're leasing property, commercial and that, industrial. Title insurance is a contract in which the policyholder is protected from losses arising from defects in the title. So if the title insurance company search title and there were defects, those will be exceptions in your policy. Like real estate taxes not yet paid or doable. That's an exception. Title company is not going to insure over those. But you will get credit if you're a buyer. A buyer will get credit at closing for the taxes that the seller still owe. Premium. Your premium for a title insurance policy is paid one time at closing. Unlike if you have car insurance, if you have homeowners insurance, if you have renter's insurance, pet insurance, whatever, a lot of times you can pay it monthly. But the premium for title is paid one time at closing, and the contract will specify who gets paid, who's paying for the policy. Subrogation, that's a new word, not to get confused with another word you learned down the road, or you've learned, or you've heard. Subordination. A subrogation is when a title company makes a payment to settle a claim covered by the policy. The company then usually will acquire all the rights to any remedies or damages available to the insured. Just like if you get into a car accident, you're told never to sign and deposit that check the insurance company gives you if you're in the process of suing the other party. Because if you sign it, that means you've accepted the settlement. And which means many times your insurance policies will have a subrogation clause, which if you sue and you win $1 million from me, your insurance company is going to get that million, not you. So never settle until everything's all done. Coverage, there's two types of policies. You have your standard coverage, which normally will insure the title as it's known from public records and insures against hidden defects. Unknown latent defects, hidden defects. And then you have your extended coverage policy. It includes protection of the standard policy, plus additional protections against defects that may be discovered by inspection of the property. Most times when you get an owner's policy, it basically is the extended coverage policy, and that's the type you want. There's also two types of policies. You have the owner's policy, which is issued for the benefit of the owner and the owner's heirs or their devisees. Many times, customarily in Illinois, the seller pays for the owner policy. The seller will provide you with the owner policy showing that they had good title. Okay? But again, as stipulated, the contract is the heart of everything. The contract may specify who's going to pay for the owner policy. Now, if you're taking out a mortgage loan with Citibank, Chase, Bank of America, that lender wants their policy too for title. They want to make sure there's clear title because they don't want somebody coming and knocking and taking the property away. Now, owner's policy will be issued for the purchase price you're paying for the property. A lender's policy is only going to be issued because it's benefiting the mortgage company, the lender. It's only going to be issued for the total amount of the loan. And as you pay the loan off, the policy amount will go down, down, down. So those are your two types of policies, and that's more or less about our title insurance and title insurance policies. We'll be coming back shortly to go on to our next chapter. See you soon.